Question 1. During the evaluation of a vehicle's condition in Ontario, a driver notices a significant and unusual noise emanating from the braking system, accompanied by a noticeable reduction in braking effectiveness. The driver is aware that their vehicle is due for its annual safety inspection next month. What is the most appropriate and legally compliant course of action? Option A. Continue driving the vehicle cautiously to a nearby mechanic, as the inspection is not yet due. Option B. Ignore the noise and braking issue, assuming it is a minor problem that will resolve itself. Option C. Attempt to drive the vehicle home and address the issue after the upcoming inspection. Option D. Immediately cease driving the vehicle and arrange for it to be towed to a licensed repair facility for diagnosis and repair. The correct answer is D. Immediately cease driving the vehicle and arrange for it to be towed to a licensed repair facility for diagnosis and repair. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the driver to balance immediate personal needs with the strict regulatory requirements for vehicle operation and safety in Ontario. The driver's desire to avoid a fine and potential inconvenience must be weighed against the legal obligation to ensure their vehicle is roadworthy and compliant with the Ontario Highway Traffic Act. Misjudging this balance can lead to legal repercussions and compromise public safety. Correct approach analysis. The best professional approach involves immediately ceasing operation of the vehicle and arranging for it to be towed to a repair facility. This approach is correct because it directly addresses the mechanical defect in a manner that fully complies with Section 40 of the Ontario Highway Traffic Act, which mandates that no person shall drive a vehicle that is not in a safe operating condition. By not driving the vehicle, the driver avoids further potential damage, prevents a safety hazard to themselves and others, and allows for proper repair before re-entering public roadways. This demonstrates a commitment to regulatory compliance and responsible vehicle ownership. Incorrect approaches analysis. Continuing to drive the vehicle, even for a short distance, is a regulatory failure. Violates Section 40 of the Ontario Highway Traffic Act by operating a vehicle in an unsafe condition. This action not only risks a significant fine and demerit points, but also poses a direct safety hazard to other road users and the driver. Attempting to limp the vehicle to a mechanic without proper assessment of the severity of the defect is inherently risky and disregards the spirit of the law, which prioritizes public safety. Ignoring the issue and hoping it resolves itself is also a failure, as it demonstrates a lack of due diligence and a disregard for legal obligations and safety. Professional reasoning. Professionals in any field, including driving, must prioritize regulatory compliance and safety. When faced with a potential mechanical issue, the decision-making process should involve 1. Recognizing the potential risk and regulatory implications. 2. Consulting relevant regulations, in this case, the Ontario Highway Traffic Act. 3. Choosing the option that most effectively mitigates risk and ensures compliance, even if it involves inconvenience. 4. Documenting the issue and the steps taken for resolution. Question 2. What factors determine the appropriate disclosure of a referral fee arrangement to a client in Ontario when recommending an investment product? Option A. Proactively disclosing the existence and nature of the referral fee to the client before making any investment recommendation. Option B. Assuming the client would not be concerned about a referral fee and therefore not disclosing it unless specifically asked. Option C. Disclosing the referral fee to the client only after they have agreed to invest in the recommended product. Option D. Recommending the investment product and then disclosing the referral fee only if the client inquires about the advisor's compensation. Correct answer is A. Proactively disclosing the existence and nature of the referral fee to the client before making any investment recommendation. Explanation. This scenario is professionally challenging because it requires a financial advisor to balance client interests with regulatory obligations, particularly concerning the disclosure of potential conflicts of interest. The advisor must navigate the complexities of provincial securities regulations in Ontario, which mandate transparency and fair dealing. The correct approach involves proactively disclosing the referral fee arrangement to the client before any recommendation is made. This aligns with the Ontario Securities Commission OSC, Rule 31-505 Conditions of Registration, and the broader ethical principles of client centricity and avoiding undisclosed conflicts. By disclosing the fee, the advisor allows the client to make an informed decision. Understanding any potential bias, that might influence the recommendation. This transparency builds trust and upholds the advisor's fiduciary duty. An incorrect approach would be to recommend the investment without disclosing the referral fee. This violates OSC Rule 31-505, which requires registrants to disclose all material facts, including compensation arrangements that could influence advice. Ethically, this is a breach of trust and constitutes a conflict of interest that has not been managed appropriately. Another incorrect approach is to disclose the referral fee only after the client has agreed to the investment. This is problematic because the client's decision has already been made under potentially incomplete information. The disclosure is no longer a tool for informed decision-making, but a post hoc justification, failing to meet the spirit and letter of regulatory disclosure requirements. A further incorrect approach is to assume the client would not be concerned about the referral fee. This demonstrates a failure to understand the client's right to full disclosure and the advisor's regulatory obligation to provide it, regardless of the advisor's personal assessment of the client's potential reaction. Professional decision-making in such situations requires a commitment to proactive, comprehensive disclosure as a default practice, prioritizing regulatory compliance and ethical conduct over assumptions about client preferences or potential discomfort. The advisor should always err on the side of transparency when in doubt. Question 3. Quality control measures reveal that a financial advisor in Ontario, Canada, is maintaining client records using a combination of handwritten notes, emails saved in personal inboxes, and transaction confirmation stored in a shared network drive. Which of the following approaches best ensures compliance with Ontario Securities Commission OSC record-keeping requirements and upholds professional standards? Option A. Continue using the current mixed system of paper notes, personal email archives, and shared drive files, with occasional manual consolidation of key information. Option B. Focus on documenting only those client communications that directly lead to a completed transaction, deeming informal discussions as less critical for record keeping. Option C. Delegate the primary responsibility for organizing and maintaining all client records to junior administrative staff, with minimal direct oversight from the advisor. Option D. Implement a centralized, secure digital record-keeping system that automatically timestamps all entries, maintains version control, and ensures data integrity for all client communications and transactions. The correct answer is D. Implement a centralized, secure digital record-keeping system that automatically timestamps all entries, maintains version control, and ensures data integrity for all client communications and transactions. Explanation. The scenario presents a professional challenge related to maintaining accurate and compliant client records within the financial services industry in Ontario, Canada. The challenge lies in balancing the need for efficient record keeping with the strict legal and ethical obligations imposed by Ontario securities regulations, specifically the Ontario Securities Commission OSC, rules and related provincial legislation. Professionals must exercise careful judgment to ensure all client interactions and decisions are properly documented and accessible, as required by law. The correct approach involves implementing a robust, centralized digital system for all client communications and transaction records. The system should be designed to automatically timestamp entries, maintain version control, and ensure data integrity. This is correct because it directly aligns with the OSC's requirements for maintaining accurate and complete records, as stipulated in National Instrument 31-103 registration requirements, exemptions, and ongoing registrant obligations. This approach ensures that all client interactions, advice given, and transactions executed are meticulously documented, providing a clear audit trail and demonstrating compliance with regulatory oversight. It also facilitates efficient retrieval of information for compliance reviews and client inquiries, upholding the duty of care owed to clients. An incorrect approach involves relying on a mix of paper-based notes and disparate digital files stored on individual computers. This is professionally unacceptable because it creates significant risks of data loss, inconsistency, and difficulty in retrieving complete client histories. Such a fragmented system makes it nearly impossible to demonstrate compliance with OSC record-keeping obligations, as it lacks a centralized, auditable trail. It also increases the likelihood of overlooking crucial client information or transaction details, potentially leading to regulatory breaches and harm to clients. Another incorrect approach is to only document client communications that directly result in a transaction, neglecting informal discussions or preliminary advice. This is ethically and regulatorily flawed because it fails to capture the full scope of the client relationship and the advice provided. Ontario securities law requires the documentation of all material communications and decisions that impact a client's investments, not just those leading to a trade. This selective documentation can obscure the basis for investment recommendations and make it difficult to defend against potential complaints or regulatory scrutiny. A final incorrect approach is to delegate record-keeping entirely to junior staff without adequate oversight or a standardized system. While delegation is a management tool, the ultimate responsibility for compliance rests with the registered individual or firm. This approach is problematic as it can lead to inconsistent documentation quality, potential errors, and a lack of accountability. It fails to establish a clear, enforceable standard for record-keeping across the organization, increasing the risk of non-compliance with OSC regulations. Professionals should adopt a decision-making framework that prioritizes regulatory compliance and client best interests. This involves proactively understanding and adhering to all relevant OSC rules and provincial legislation regarding record-keeping. Regular training, implementation of standardized digital systems, and ongoing internal audits are crucial to ensure that all client interactions are accurately and comprehensively documented. When in doubt, seeking guidance from compliance officers or legal counsel is essential to maintain the highest professional standards. Question 4. The control framework reveals that in Ontario, Canada, a financial advisor is considering recommending an investment product to a client. The advisor will receive a referral fee from the product provider for this recommendation. Which of the following actions best upholds the advisor's regulatory and ethical obligations? Option A. Verbally inform the client about the referral fee during the discussion about the investment, without providing any written documentation. Option B. Do not disclose the referral fee, assuming it is a standard business practice and not material to the client's decision. Option C. Disclose the referral fee to the client only after they have agreed to invest in the product. Option D. Provide the client with a written disclosure of the referral fee arrangement and its potential impact on the recommendation before proceeding with the investment. The correct answer is D. Provide the client with a written disclosure of the referral fee arrangement and its potential impact on the recommendation before proceeding with the investment. Explanation. The control framework reveals a scenario where a financial advisor in Ontario, Canada, must navigate the complexities of client disclosure and potential conflicts of interest. This situation is professionally challenging because it requires balancing the advisor's duty to act in the client's best interest with the need to disclose all material information, including potential conflicts, as mandated by regulatory bodies. The advisor must exercise careful judgment to ensure transparency and maintain client trust, which are cornerstones of ethical financial practice. The best approach involves proactively and comprehensively disclosing the referral fee arrangement to the client in writing, prior to recommending the investment. This approach aligns with the principles of client centricity and the regulatory requirements of the Ontario Securities Commission, OSC, and the Investment Industry Regulatory Organization of Canada, IIROC. Specifically, such disclosure ensures compliance with rules regarding conflicts of interest and the duty to act honestly, fairly, and in good faith. By providing the client with all material information, including the financial benefit the advisor receives from the referral, the client is empowered to make an informed decision, thereby upholding the advisor's fiduciary duty. An incorrect approach would be to only verbally mention the referral fee to the client without providing written documentation. This fails to create a clear and verifiable record of disclosure, leaving room for misinterpretation or the client forgetting the details. It also falls short of the robust disclosure standards expected by regulators, which often require written confirmation of material information. Another incorrect approach would be to fail to disclose the referral fee altogether, assuming the client would not be concerned or that it is a minor detail. This is a direct violation of regulatory obligations concerning conflicts of interest and the duty to disclose all material facts that could influence a client's decision. Such an omission erodes client trust and exposes the advisor and their firm to significant regulatory penalties. A further incorrect approach would be to disclose the fee only after the client has agreed to the investment. This is problematic as it implies the disclosure is an afterthought rather than a prerequisite for informed consent, potentially making the client feel misled and undermining the integrity of the recommendation process. Professionals should adopt a decision-making framework that prioritizes transparency and client well-being. This involves a proactive assessment of potential conflicts of interest in every client interaction. When a conflict arises, the professional should immediately consider the most effective and verifiable method of disclosure, typically in writing, ensuring the client has ample opportunity to understand the implications before making any decisions. This process should be guided by a thorough understanding of applicable regulations and ethical codes, always erring on the side of over-disclosure to ensure client protection and maintain professional integrity. Question 5. Process analysis reveals that a client in Ontario who has been following a long-term, diversified investment strategy is now urgently requesting to liquidate a significant portion of their portfolio to invest in a highly speculative, unproven technology company. The client expresses strong conviction in this new venture, citing anecdotal information and a desire for rapid gains, despite the inherent volatility and lack of established track record of the proposed investment. Which of the following approaches best aligns with regulatory compliance and professional ethical standards for an investment advisor in Ontario? Option A. Inform the client that their request cannot be fulfilled due to the speculative nature of the investment, and proceed with maintaining the existing investment portfolio as per the original plan. Option B. Advise the client that the proposed investment is too risky and suggest alternative, more conservative investments that align with their original investment strategy, without further exploring the client's rationale for the speculative request. Option C. Immediately execute the client's request to liquidate the portfolio and invest in the speculative company, as the client has provided explicit instructions and appears confident in their decision. Option D. Engage in a detailed discussion with the client to thoroughly explain the risks associated with the speculative investment, the potential negative impact on their long-term financial goals, and the importance of adhering to their established investment plan, while meticulously documenting the conversation and the client's final decision. Correct answer is D. Engage in a detailed discussion with the client to thoroughly explain the risks associated with the speculative investment, the potential negative impact on their long-term financial goals, and the importance of adhering to their established investment plan, while meticulously documenting the conversation and the client's final decision. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's explicit, albeit potentially ill-informed, instructions and the advisor's fiduciary duty to act in the client's best interest, guided by regulatory principles. The advisor must navigate the client's emotional state and perceived urgency while upholding their professional obligations under the Ontario Securities Commission (OSC) regulations. The challenge lies in balancing client autonomy with the advisor's responsibility to prevent harm and ensure compliance. Correct approach analysis. The best professional practice involves a multifaceted approach that prioritizes client education and understanding before executing any transaction. This includes clearly explaining the risks associated with the proposed investment, detailing the potential negative consequences of deviating from a well-established investment plan, and documenting the client's decision-making process thoroughly. This approach aligns with the OSC's emphasis on suitability, know your client (KIC) principles, and the duty to provide advice that is in the client's best interest. By ensuring the client fully comprehends the implications of their request, the advisor fulfills their obligation to act prudently and ethically, mitigating potential future complaints or regulatory scrutiny. Incorrect approaches analysis. Proceeding with the transaction immediately without further discussion or explanation fails to uphold the advisor's duty of care and suitability obligations under OSC regulations. It prioritizes the client's immediate instruction over a comprehensive assessment of the client's best interests and understanding of the risks involved. This could lead to significant financial harm for the client and expose the advisor to regulatory action for failing to provide appropriate advice. Suggesting alternative, less risky investments without first addressing the client's specific request and explaining the implications of their proposed action is also problematic. While well-intentioned, it bypasses the crucial step of ensuring the client understands the consequences of their original instruction. This approach may not adequately address the client's underlying concerns or motivations for the proposed transaction, potentially leading to dissatisfaction or a perception of not being heard. Ignoring the client's request and proceeding with the existing investment plan without any engagement is a direct contravention of the client's instructions and can damage the advisor-client relationship. It also fails to acknowledge the client's right to make informed decisions, even if those decisions are not what the advisor would recommend. This approach neglects the importance of open communication and client consent, which are fundamental to ethical financial advisory practice under OSC guidelines. Professional reasoning. Professionals should adopt a structured decision-making process that begins with active listening to understand the client's request and underlying motivations. This should be followed by a thorough assessment of the request's implications in light of the client's financial goals, risk tolerance, and existing investment plan. Crucially, the advisor must then engage in clear, transparent communication, educating the client about the risks and benefits of their proposed action and any alternatives. Documentation of all discussions and decisions is paramount to demonstrate adherence to regulatory requirements and ethical standards. Question 6. The performance metrics show a slight hesitation in the braking system of a company vehicle during a pre-trip inspection in Ontario. The driver is on a tight schedule for a delivery that is critical for a major client. What is the most appropriate course of action for the driver? Option A. Continue with the delivery route as planned, assuming the braking hesitation is minor and will not impact the delivery's timely completion. Option B. Attempt to adjust or temporarily fix the braking system themselves to avoid delaying the delivery schedule. Option C. Complete the scheduled delivery and report the braking hesitation to the supervisor only after the delivery is successfully concluded. Option D. Immediately report the suspected braking issue to their supervisor or fleet manager and await further instructions before proceeding with the delivery. Correct answer is D. Immediately report the suspected braking issue to their supervisor or fleet manager and await further instructions before proceeding with the delivery. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a driver to balance the immediate need to complete a task with the overarching regulatory obligation to ensure vehicle safety. The driver's personal assessment of the vehicle's condition, even if seemingly minor, must be weighed against the legal requirements for roadworthiness in Ontario. Failure to adhere to these regulations can lead to significant penalties, compromise public safety, and damage the driver's professional standing. Careful judgment is required to determine when a perceived issue necessitates immediate action versus when it can be addressed through standard procedures. Correct approach analysis. The best professional practice involves immediately reporting the suspected issue to the designated supervisor or fleet manager, as per Ontario's Highway Traffic Act and the company's internal safety protocols. This approach is correct because it prioritizes safety and regulatory compliance. The Highway Traffic Act mandates that vehicles operated on Ontario roads must be in a safe condition. By reporting the suspected issue, the driver initiates the formal process for inspection and repair, ensuring that the vehicle is not operated in a potentially unsafe state. This also protects the driver from liability and upholds the company's commitment to safety standards. Incorrect approach is analysis, reporting the issue only after completing the delivery, even if the vehicle appears to function adequately, is professionally unacceptable. This approach violates the spirit and letter of the Highway Traffic Act by potentially operating an unsafe vehicle. The driver is assuming the risk that the issue is minor, which could be incorrect, leading to an accident or breakdown that endangers themselves and others. Continuing the route without reporting the suspected issue, assuming it will not affect the delivery, is also professionally unacceptable. This demonstrates a disregard for safety regulations and company policy. The driver is prioritizing task completion over legal obligations and the safety of the public and themselves. This could lead to severe consequences if the suspected issue escalates and causes an incident. Attempting to diagnose and fix the suspected issue independently without proper authorization or expertise is professionally unacceptable. This bypasses established safety procedures and could lead to improper repairs, further damaging the vehicle or creating a new safety hazard. It also places the driver in a position of performing maintenance they may not be qualified for, potentially violating workplace safety regulations. Professional reasoning. Professionals should employ a risk-based decision-making framework. When a potential safety issue is identified, the immediate priority is to mitigate risk. This involves stopping the operation of the potentially unsafe equipment and reporting it through the established channels. The framework should prioritize regulatory compliance and ethical responsibility over expediency. Drivers should be trained to recognize potential safety concerns and understand the reporting procedures. If unsure, erring on the side of caution and reporting is always the safest and most compliant course of action. Question 7. The performance metrics show a high demand for new driver training in Ontario, prompting a driving school owner to consider hiring instructors who have recently submitted their applications for MTO driver instructor licenses, but are awaiting official confirmation. Which of the following actions best demonstrates adherence to regulatory compliance and professional responsibility? Option A. Ensure all potential instructors have their MTO driver instructor license applications fully approved and documented before allowing them to provide any instruction. Option B. Proceed with instruction if the individual possesses a valid Ontario driver's license, assuming this implicitly qualifies them as an instructor. Option C. Permit instructors to start teaching based on verbal assurances from MTO staff that their applications are being processed. Option D. Allow instructors to begin training students while their MTO driver instructor license applications are still pending, based on the assumption of approval. The correct answer is A. Ensure all potential instructors have their MTO driver instructor license applications fully approved and documented before allowing them to provide any instruction. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires balancing the need for efficient service delivery with the absolute imperative of adhering to the specific licensing and registration requirements mandated by the Ontario Ministry of Transportation, MTO, for driver instructors. Failure to comply can lead to significant penalties for both the instructor and the driving school, and more importantly, can invalidate the training provided to students, potentially compromising road safety. Careful judgment is required to ensure all regulatory obligations are met before commencing instruction. Correct approach analysis. The best professional practice involves verifying that all necessary MTO licensing and registration requirements are fully met and documented before providing any driver instruction. This approach ensures compliance with the Ontario Highway Traffic Act and its associated regulations. Specifically, it aligns with the MTO's stringent requirements for driver instructor licensing, which include background checks, examination, and adherence to professional conduct standards. By confirming all prerequisites are satisfied, the instructor and the driving school operate within the legal framework, protecting students and maintaining the integrity of the licensing process. Incorrect approaches analysis. One incorrect approach involves commencing instruction while awaiting confirmation of licensing, assuming the application will be approved. This is a regulatory failure because it violates the MTO's requirement that instructors must be fully licensed before providing instruction. This practice bypasses the MTO's due diligence process and exposes the instructor and school to penalties, and the instruction provided may be deemed invalid. Another incorrect approach is to rely on informal assurances from the MTO or a colleague that the license is in progress and proceed with teaching. This is an ethical and regulatory failure, as it substitutes informal communication for official documentation and verification. The MTO's regulations require formal proof of licensing, and informal assurances do not constitute legal authorization to instruct. This approach demonstrates a disregard for established procedures and can lead to serious consequences. A further incorrect approach is to believe that having a valid driver's license automatically qualifies one to instruct, without obtaining the specific MTO driver instructor license. This is a fundamental misunderstanding of the regulatory framework. The MTO has a distinct licensing process for instructors that goes beyond simply holding a regular driver's license, focusing on pedagogical skills, knowledge of traffic laws, and safe driving practices relevant to teaching others. Professional reasoning. Professionals in this field should adopt a proactive and diligent approach to regulatory compliance. This involves thoroughly understanding all licensing and registration requirements specific to the jurisdiction, in this case, Ontario. Before undertaking any professional activity that requires a license, individuals should obtain official confirmation of their licensing status. This confirmation should be documented and readily available. In situations of uncertainty, it is always best to err on the side of caution and seek clarification directly from the regulatory body, the MTO, through official channels rather than relying on assumptions or informal communications. This systematic approach ensures that all legal and ethical obligations are met, safeguarding both the professional and the public. Question 8. System analysis indicates that a financial advisor in Ontario, Canada, has a client who has expressed a strong desire to invest a significant portion of their portfolio in a highly speculative technology startup. The client has previously indicated a moderate risk tolerance and has a relatively stable but not extensive financial base. The advisor has reviewed the client's profile and believes this investment is not suitable given the stated risk tolerance and the client's financial capacity to absorb potential losses. What is the most appropriate course of action for the advisor to take, adhering to Ontario Securities Commission (OSC) regulations and Investment Industry Regulatory Organization of Canada (IIROC) rules? Option A. Recommend the investment but include a disclaimer in the client agreement stating that the investment is highly speculative and the client assumes all risk without further detailed suitability analysis. Option B. Advise the client that the investment is too risky and suggest they seek advice from a different advisor who might be more willing to accommodate their request. Option C. Proceed with the investment as requested by the client, assuming the client understands the risks involved and is making an informed decision, and simply document the client's request. Option D. Conduct a thorough suitability assessment. Clearly explain the risks and potential downsides of the speculative investment to the client, document the discussion, and if the investment remains unsuitable, advise against it and propose alternative, more suitable investments aligned with the client's profile. The correct answer is D. Conduct a thorough suitability assessment. Clearly explain the risks and potential downsides of the speculative investment to the client, document the discussion, and if the investment remains unsuitable, advise against it and propose alternative, more suitable investments aligned with the client's profile. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a financial advisor in Ontario, Canada, to navigate the delicate balance between client requests and their fiduciary duty to act in the client's best interest, adhering to the Ontario Securities Commission (OSC) regulations and the Investment Industry Regulatory Organization of Canada (IIROC) rules. The client's desire for a specific, high-risk investment, despite their stated risk tolerance and financial situation, creates a conflict that demands careful judgment and a robust compliance framework. The advisor must avoid simply acceding to the client's wishes without proper due diligence and consideration of regulatory obligations. Correct approach analysis. The best professional practice involves a thorough assessment of the client's financial situation, investment objectives, and risk tolerance, followed by a detailed explanation of the risks and suitability of the proposed investment. This approach aligns with the OSC's client-focused regulation and IIROC dealer member rules, which mandate that registrants must ensure that any recommendation or transaction is suitable for the client. The advisor must document this assessment and the client's understanding of the risks, even if it means advising against the specific investment requested. This demonstrates a commitment to the client's best interest and compliance with regulatory requirements for suitability and know your client (KIC) principles. Incorrect approach is analysis. Recommending the investment without a comprehensive suitability assessment, simply because the client requested it, violates the fundamental duty to act in the client's best interest and contravenes OSC and IIROC suitability rules. This approach prioritizes client satisfaction over regulatory compliance and client protection. Proceeding with the investment after a cursory discussion of risks, without a deep dive into the client's capacity to absorb potential losses, also falls short of regulatory expectations. This approach risks misrepresenting the investment's suitability and could lead to significant client harm, triggering regulatory scrutiny. Accepting the client's assertion of understanding without independently verifying their comprehension of the complex risks associated with the specific investment is also a failure. This bypasses the advisor's responsibility to ensure genuine understanding, which is crucial for informed decision-making and regulatory compliance. Professional reasoning. Professionals should employ a structured decision-making process that begins with a comprehensive understanding of client needs and regulatory obligations. This involves a detailed KYC process, followed by a rigorous suitability assessment for any proposed investment. When a client requests a specific investment, The advisor must critically evaluate its alignment with the client's profile and regulatory requirements. If there is a mismatch, the advisor must clearly communicate the concerns, explain the risks, and offer suitable alternatives. Documentation of all discussions, assessments, and decisions is paramount for demonstrating compliance and protecting both the client and the advisor. Question 9. Benchmark analysis indicates that a financial advisor in Ontario, Canada, has a client who is adamant about investing a substantial portion of their portfolio into a highly speculative, unproven cryptocurrency with a history of extreme volatility and a significant risk of total loss. The client has provided a direct instruction to proceed. Considering the regulatory framework governing financial advice in Ontario, which of the following represents the most appropriate course of action for the advisor? Option A. Proceed with the investment as instructed, but make a note in the client's file to monitor the investment closely and attempt to mitigate losses if they occur. Option B. Engage in a comprehensive discussion with the client to thoroughly explain the extreme risks associated with the proposed investment. Assess their understanding of these risks in relation to their overall financial situation and objectives, and document this conversation and the client's informed consent before proceeding. Option C. Immediately execute the client's instruction to invest in the cryptocurrency, as the client has provided a direct order and the advisor's role is to follow client directives. Option D. Refuse the client's request outright and inform them that the advisor cannot facilitate such a high-risk investment without further discussion or exploration of the client's reasoning. Correct answer is B. Engage in a comprehensive discussion with the client to thoroughly explain the extreme risks associated with the proposed investment. Assess their understanding of these risks in relation to their overall financial situation and objectives, and document this conversation and the client's informed consent before proceeding. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a financial advisor in Ontario, Canada, to navigate the complex interplay between client instructions, regulatory obligations, and the advisor's duty of care. The advisor must balance respecting the client's autonomy with ensuring that the client's decisions are informed and do not expose them to undue risk or violate securities regulations. The pressure to comply with a client's potentially ill-advised request, especially when it involves significant financial implications, demands careful judgment and adherence to established ethical and regulatory frameworks. Correct approach analysis. The best professional practice involves a thorough and documented discussion with the client to understand the rationale behind their request to invest in a high-risk, speculative security. This approach requires the advisor to explain the inherent risks associated with such an investment, including the potential for significant loss of capital, and to assess the client's understanding of these risks in the context of their overall financial situation, risk tolerance, and investment objectives. If after this discussion, the client remains insistent and demonstrates a clear understanding of the risks, the advisor may proceed, but only after obtaining explicit, informed consent and documenting the entire process. This aligns with the Ontario Securities Commission (OSC) Rule 31-505 registration requirements, specifically the provisions related to suitability and know your client (KIC) obligations, which mandate that advisors act in the best interest of their clients and ensure investments are suitable. Incorrect approach is analysis. Proceeding with the investment without a detailed discussion and clear understanding of the client's rationale and risk awareness would be a significant regulatory failure. This bypasses the fundamental KYC obligations under OSC Rule 31-505, which require advisors to gather sufficient information to make suitable recommendations. Accepting the client's instructions solely based on their direct request, without due diligence, could lead to a breach of the advisor's duty to act in the client's best interest. Another incorrect approach would be to refuse the client's request outright without attempting to understand their motivations or educate them on the risks. While the advisor has a duty to prevent unsuitable investments, complete refusal without engagement can damage the client relationship and may not be the most constructive solution if the client has a legitimate, albeit perhaps misunderstood, reason for their request. Finally, proceeding with the investment and then attempting to mitigate potential losses after the fact, rather than proactively assessing suitability and risk, is a reactive and unprofessional approach that fails to meet the preventative obligations of a financial advisor. Professional reasoning. Professionals should employ a structured decision-making process that prioritizes client well-being and regulatory compliance. This involves 1. Active listening and information gathering. Understand the client's request and underlying motivations. 2. Risk assessment and education. Clearly articulate the risks and potential consequences of the proposed action, ensuring the client comprehends them. 3. Suitability evaluation. Assess the proposed action against the client's established financial profile, objectives, and risk tolerance. 4. Documentation. Meticulously record all discussions, advice given, client decisions, and the rationale behind them. 5. Compliance check. Ensure all actions align with relevant provincial securities regulations, such as those enforced by the OSC. If a client's request consistently conflicts with these principles, the advisor must consider whether continuing the professional relationship is appropriate. Question 10. Operational review demonstrates that a client in Ontario realized a capital gain of $50,000 from the sale of an investment property. The current capital gains inclusion rate in Ontario is 50%. What is the amount of the taxable capital gain that should be reported for Ontario provincial tax purposes? Option A, $50,000. Option B, $25,000. Option C, $0. Option D, $37,500. The correct answer is B, $25,000. Explanation: scenario analysis. This scenario presents a professional challenge related to the accurate calculation and reporting of a client's tax liability, specifically concerning capital gains. The complexity arises from the need to correctly apply the Ontario provincial tax rules, including the capital gains inclusion rate, and to ensure the client is not misled by an incomplete calculation. Misinterpreting tax laws or failing to account for all relevant factors can lead to significant financial penalties for the client and reputational damage for the advisor. Correct approach analysis. The best professional practice involves a comprehensive calculation that accurately reflects the capital gains inclusion rate as stipulated by Ontario tax legislation. This approach correctly identifies the taxable portion of the capital gain by multiplying the total capital gain by the inclusion rate. For example, if the inclusion rate is 50%, only half of the capital gain is subject to tax. This method ensures compliance with provincial tax laws and provides the client with an accurate estimate of their tax obligation. Incorrect approaches analysis. One incorrect approach involves calculating the tax on the entire capital gain without applying the inclusion rate. This failure to adhere to the specific provincial tax rules for capital gains leads to an overestimation of the tax liability and a misrepresentation of the client's financial position. Another incorrect approach is to simply state the total capital gain without any tax calculation, implying that no tax is due. This is fundamentally flawed as it ignores the taxable nature of capital gains under Ontario law and fails to provide any useful tax planning information to the client. A further incorrect approach is to apply a generic tax rate without considering the specific capital gains inclusion rules. While a tax rate might be applied, the failure to correctly determine the taxable gain first renders the final tax calculation inaccurate and non-compliant with Ontario's tax framework. Professional reasoning. Professionals should always prioritize understanding and applying the specific tax legislation of the relevant jurisdiction. This involves a systematic approach. First, accurately determining the total capital gain. Second, applying the correct capital gains inclusion rate as defined by provincial law. And third, calculating the tax based on the resulting taxable gain and the applicable tax rates. When in doubt, seeking clarification from official tax resources or consulting with a tax specialist is crucial. Question 11. Strategic planning requires a financial advisor in Ontario, Canada, to consider how to onboard a new high-net-worth client who is eager to invest in a complex, high-risk product that promises substantial returns, but which the advisor's initial assessment suggests may be unsuitable for the client's stated risk tolerance and investment experience. What is the most appropriate course of action for the advisor to take? Option A. Seek a simplified version of the suitability assessment that focuses primarily on the client's stated desire to invest in the product, overlooking potential discrepancies with their risk tolerance. Option B. Minimize the discussion of the product's risks and emphasize its potential rewards to persuade the client that it is a suitable investment, thereby securing the client's business. Option C. Conduct a thorough suitability assessment, including a detailed review of the client's financial situation, investment objectives, and risk tolerance. And if the product is deemed unsuitable, decline the investment and explain the reasoning to the client, offering alternative suitable options. Option D. Proceed with the investment as requested by the client, focusing on the potential for high returns and the client's expressed desire, and prioritize securing the new business and associated commission. The correct answer is C. Conduct a thorough suitability assessment, including a detailed review of the client's financial situation, investment objectives, and risk tolerance, and if the product is deemed unsuitable, decline the investment and explain the reasoning to the client, offering alternative suitable options. Explanation. Strategic planning requires a thorough understanding of regulatory compliance to ensure all business operations adhere to the law and ethical standards. In the context of Ontario, Canada, financial advisors must navigate the Ontario Securities Commission (OSC) rules and regulations. This scenario is professionally challenging because it pits the immediate financial benefit of a new client against the advisor's obligation to conduct thorough due diligence. Failing to properly assess a client's suitability for a particular investment product, especially one with higher risk, can lead to significant financial harm for the client and severe regulatory repercussions for the advisor and their firm. The advisor must balance client acquisition with their fiduciary duty and compliance obligations. The best approach involves prioritizing the client's best interests and regulatory requirements over immediate revenue generation. This means conducting a comprehensive Know Your Client KIC process, including a detailed assessment of the client's financial situation, investment objectives, risk tolerance, and investment knowledge. If the proposed investment product does not align with these factors, the advisor must decline to proceed with the transaction and explain the reasoning to the client, potentially suggesting alternative, more suitable investments. This aligns with OSC Rule 31-505 Conditions of Registration, which mandates that registrants must deal fairly, honestly, and in good faith with clients, and act in the best interests of their clients. An incorrect approach would be to proceed with the investment solely based on the client's stated desire and the potential for commission. This disregards the advisor's duty to assess suitability and could lead to the client making an investment that is beyond their risk capacity, violating OSC regulations regarding suitability and client protection. Another incorrect approach would be to downplay the risks associated with the investment to secure the business. This constitutes misleading the client and breaches the ethical obligation of transparency and honesty, as well as OSC requirements for providing accurate and complete information. Finally, attempting to find a loophole or a less stringent interpretation of the rules to accommodate the client's request without genuine consideration of their best interests would also be a failure of professional conduct and regulatory compliance. Professionals should employ a decision-making framework that begins with identifying all relevant regulatory obligations and ethical principles. They should then gather all necessary information about the client and the proposed product. Next, they must objectively assess whether the product is suitable for the client based on the gathered information and regulatory standards. If there is a mismatch, the professional must communicate this clearly and professionally to the client, offering alternatives or explaining why the proposed investment is not appropriate. This systematic process ensures that client well-being and regulatory adherence are paramount. Question 12. The assessment process reveals that a driver in Saskatchewan is running late for an important appointment and is considering exceeding the posted speed limit on a highway to make up for lost time. Which of the following approaches best demonstrates adherence to the principles of the Nelson Driver's Test and Saskatchewan traffic regulations? Option A. Focus on reaching the destination as quickly as possible, only slowing down if a police vehicle is visible. Option B. Drive at speed that feels comfortable and allows for reaching the destination quickly, regardless of the posted limit. Option C. Maintain the posted speed limit or a speed appropriate for the road and weather conditions, accepting the possibility of arriving late. Option D. Exceed the posted speed limit to make up for lost time and arrive at the appointment on schedule. The correct answer is C. Maintain the posted speed limit or a speed appropriate for the road and weather conditions, accepting the possibility of arriving late. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the driver to balance the immediate need to reach a destination with the paramount importance of adhering to traffic laws and ensuring public safety. The temptation to exceed the speed limit to make up for lost time can be significant, but the legal and ethical implications of such an action are severe. Careful judgment is required to prioritize safety and compliance over personal convenience or perceived urgency. Correct approach analysis. The best professional practice involves maintaining a safe and legal speed, even if it means arriving later than anticipated. This approach is correct because it directly aligns with the fundamental principles of the Nelson Driver's Test, which emphasizes responsible and lawful operation of a vehicle. Specifically, adhering to posted speed limits and driving at a speed appropriate for the conditions is a core requirement of the Nelson Driver's Test syllabus and is mandated by the traffic laws of Saskatchewan. This ensures the safety of the driver, passengers, and other road users, and avoids potential legal penalties. Incorrect approaches analysis. Exceeding the posted speed limit to make up for lost time is professionally unacceptable. This action directly violates Saskatchewan traffic laws regarding speed limits and demonstrates a disregard for public safety. It increases the risk of accidents due to reduced reaction time and greater impact force in the event of a collision. Driving at a speed that is too fast for the prevailing road and weather conditions, even if below the posted limit, is also professionally unacceptable. The posted limit may be a maximum. Drivers are legally obligated to adjust their speed to ensure safe operation. Failing to do so, even if technically within the posted limit, can still lead to a loss of control and accidents, violating the spirit and letter of safe driving practices taught in the Nelson Driver's Test. Focusing solely on the destination and disregarding the posted speed limit is professionally unacceptable. This prioritizes personal convenience over legal obligations and public safety, which is contrary to the ethical responsibilities of a licensed driver. It demonstrates a lack of judgment and an unwillingness to operate a vehicle responsibly. Professional reasoning. Professionals should employ a decision-making framework that prioritizes safety and legal compliance above all else. This involves a continuous assessment of the driving environment, including speed limits, road conditions, weather, and traffic density. When faced with a situation where time is a factor, the professional should first consider if it is possible to arrive on time while maintaining safe and legal speeds. If not, the professional must accept the delay and continue to drive responsibly, rather than compromising safety or breaking the law. The Nelson Driver's Test aims to instill this disciplined and responsible approach to driving. Question 13. The evaluation methodology shows that a financial advisor in Ontario, Canada, has a client who is eager to invest in a newly launched technology fund. Upon reviewing the fund's prospectus, the advisor identifies significant risks that appear inconsistent with the client's previously established risk tolerance and financial goals. What is the most appropriate course of action for the advisor to take in this situation? Adhering to Ontario's regulatory framework. Option A. Proceed with the investment in the technology fund as requested by the client, assuming the client's expressed desire overrides their previously stated risk tolerance. Option B. Recommend the technology fund but downplay the identified risks to avoid discouraging the client from making the investment. Option C. Clearly explain the identified risks to the client, detailing how they conflict with the client's established risk tolerance and financial objectives, and propose alternative investments that better align with the client's profile. Option D. Strongly advise the client to invest in a more conservative fund without fully exploring the client's current motivations or the specific risks of the technology fund. Correct answer is C. Clearly explain the identified risks to the client, detailing how they conflict with the client's established risk tolerance and financial objectives, and propose alternative investments that better align with the client's profile. Explanation. The evaluation methodology shows that a financial advisor in Ontario, Canada, is tasked with advising a client on a significant investment decision. The client, a long-time resident of Ontario, has expressed a strong desire to invest in a new technology fund that has recently launched. The advisor has reviewed the fund's prospectus and identified potential risks that are not fully aligned with the client's stated risk tolerance and financial goals, which were established during their initial onboarding process. This scenario is professionally challenging because the advisor must balance the client's expressed wishes with their fiduciary duty to act in the client's best interest, adhering to Ontario's securities regulations, and the ethical standards set by bodies like the Mutual Fund Dealers Association of Canada, MFDA. The best approach involves prioritizing the client's established financial profile and regulatory obligations. This means clearly communicating the identified risks of the new fund to the client, explaining how they diverge from the client's stated risk tolerance and financial objectives, and recommending alternative investments that are more suitable. This aligns with the advisor's duty under Ontario securities law to ensure that recommendations are suitable for the client and that the client understands the risks involved. It also upholds the MFDA Rule 2.1 regarding Know Your Client KIC and suitability, which mandates that members must ensure that any recommendation is suitable for the client based on their financial circumstances, investment objectives, risk tolerance, and knowledge and experience. An incorrect approach would be to proceed with the investment solely based on the client's expressed desire, without adequately addressing the identified risks and suitability concerns. This fails to meet the advisor's fiduciary duty and contravenes Ontario securities regulations that require suitability assessments. Another incorrect approach would be to push the client towards a different, more conservative investment without fully explaining the rationale or exploring if the client's objectives have genuinely changed, potentially alienating the client and failing to provide a comprehensive advisory service. Finally, recommending the fund without thoroughly documenting the risk disclosure and the client's decision to proceed despite warnings would also be a failure, as it leaves the advisor vulnerable and does not demonstrate due diligence in protecting the client. Professionals should employ a structured decision-making process that begins with a thorough understanding of the client's profile, KIC. When a client expresses interest in an investment that appears to conflict with this profile, the professional must engage in a detailed discussion. This involves clearly articulating the discrepancies, explaining the implications of the risks, and exploring the client's motivations. The advisor should then present suitable alternatives, ensuring the client is fully informed to make an educated decision. Documentation of all discussions, disclosures, and the client's final decision is paramount for compliance and client protection. Question 14. Analysis of a client's request in Ontario for a specific, high-risk investment that appears to contradict their stated conservative financial goals. What is the most appropriate course of action for a licensed financial advisor? Option A. Proceed with the investment as requested by the client, assuming they have fully considered the implications and are aware of the risks. Option B. Recommend the client seek advice from another advisor who might be more willing to accommodate their request. Option C. Investigate the investment further to confirm its legitimacy before proceeding, without necessarily re-evaluating its suitability for the client's goals. Option D. Conduct a detailed suitability assessment, discuss the risks and potential conflicts with the client, and present alternative compliance strategies that align with their stated goals. The correct answer is D. Conduct a detailed suitability assessment, discuss the risks and potential conflicts with the client, and present alternative compliance strategies that align with their stated goals. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated wishes and the advisor's fiduciary duty to act in the client's best interest, particularly when those wishes might lead to suboptimal outcomes or regulatory breaches. The advisor must navigate this delicate balance while adhering strictly to the regulatory framework governing financial advice in Ontario. The challenge lies in providing advice that is both compliant and genuinely beneficial to the client, even when the client's initial direction may seem straightforward. Correct approach analysis. The best professional practice involves a thorough understanding of the client's financial situation, risk tolerance, and objectives, followed by providing tailored recommendations that align with these factors and Ontario's regulatory requirements. This approach prioritizes the client's long-term well-being and ensures that any advice given is suitable and compliant. Specifically, under Ontario's securities legislation and the regulatory expectations for financial advisors, a duty of care and a requirement for suitability assessments are paramount. The advisor must act honestly, in good faith, and with a view to the best interests of the client. This necessitates a comprehensive fact-finding process and the presentation of options that are demonstrably in the client's best interest, even if they differ from the client's initial, potentially uninformed request. Incorrect approaches analysis. Recommending the investment solely based on the client's stated preference without a suitability assessment is a failure to uphold the advisor's fiduciary duty and violates Ontario's regulatory requirements for suitability. This approach prioritizes client satisfaction over client welfare and regulatory compliance, proceeding with the investment without further discussion, assuming the client fully understands the implications, demonstrates a lack of diligence and a disregard for the advisor's responsibility to educate and guide the client. This could lead to unsuitable investments and potential harm to the client's financial health, exposing the advisor to regulatory sanctions. Suggesting the client seek advice from another advisor simply to fulfill the request without attempting to understand the underlying reasons for the client's preference or offering compliant alternatives abdicates the advisor's professional responsibility. While referring a client is sometimes appropriate, doing so solely to avoid the difficult conversation of suitability and compliance is not. Professional reasoning. Professionals should employ a structured decision-making process that begins with a comprehensive understanding of the client's needs and objectives, followed by a rigorous assessment of suitability based on regulatory guidelines. When a client's request conflicts with these principles, the professional must engage in open and honest communication, explaining the rationale behind their recommendations and the potential consequences of alternative actions. The ultimate goal is to provide advice that is both compliant with Ontario's regulations and genuinely serves the client's best interests, fostering trust and long-term client relationships. Question 15. The review process indicates that a financial advisor in Ontario is considering recommending a particular mutual fund to a client. The advisor notes that this fund offers a significantly higher commission payout to them compared to other suitable alternatives that meet the client's investment objectives. What is the most appropriate course of action for the advisor to take? Option A. Recommend a fund that the advisor is most familiar with, without a detailed suitability assessment, as it is likely to be a reasonable option. Option B. Recommend the fund that offers the highest commission, assuming it generally meets the client's basic investment needs. Option C. Proceed with recommending the fund with the higher commission without disclosing the compensation difference to the client, as it is a standard practice. Option D. Recommend the fund that best aligns with the client's stated financial goals and risk tolerance after a thorough suitability assessment, and disclose any potential conflicts of interest related to compensation. The correct answer is D. Recommend the fund that best aligns with the client's stated financial goals and risk tolerance after a thorough suitability assessment, and disclose any potential conflicts of interest related to compensation. Explanation. The review process indicates a potential conflict between a financial advisor's personal interests and their duty to their client. This scenario is professionally challenging because it requires the advisor to navigate a situation where their compensation structure might incentivize a recommendation that is not purely in the client's best interest. Careful judgment is required to ensure that client welfare remains paramount, even when personal financial gain is a possibility. The best professional practice involves prioritizing the client's financial well-being above all else. This means thoroughly evaluating all available investment options based on the client's stated objectives, risk tolerance, and financial situation, and then recommending the option that best serves those needs, irrespective of any differential commission or fee structure. In Ontario, under the Financial Services Regulatory Authority of Ontario, FSRA guidelines and the Securities Act, Ontario, advisors have a fiduciary duty to act in the best interest of their clients. This duty mandates that recommendations must be suitable and prioritize client needs, even if it means forgoing a higher commission. Transparency about any potential conflicts of interest is also crucial. Recommending an investment solely because it offers a higher commission, without a thorough suitability assessment, is a regulatory and ethical failure. This violates the advisor's fiduciary duty and the principle of acting in the client's best interest, as mandated by FSRA. Such an action could lead to significant client harm and regulatory sanctions. Suggesting an investment based on a vague understanding of the client's needs, without detailed inquiry and analysis, is also unacceptable. This demonstrates a lack of due diligence and a failure to meet the suitability requirements. The advisor must gather comprehensive information to ensure the recommendation aligns with the client's specific circumstances. Failing to disclose the higher commission structure to the client before making a recommendation is a serious ethical and regulatory breach. Transparency is a cornerstone of client trust and regulatory compliance. Without full disclosure, the client cannot make an informed decision, and the advisor is operating with a hidden conflict of interest. Professionals should employ a decision-making framework that begins with a clear understanding of the client's needs and objectives. This should be followed by a comprehensive analysis of suitable investment options, considering all relevant factors including risk, return, liquidity, and cost. Any potential conflicts of interest, such as differential compensation, must be identified and disclosed to the client upfront. The final recommendation should be based solely on what is demonstrably in the client's best interest, supported by clear reasoning and documentation. Question 16. Performance analysis shows that a financial advisor in Ontario, Canada, has a client who has expressed a strong desire to invest in a particular high-risk speculative stock. The advisor has conducted a preliminary review and believes this investment is not suitable for the client's current financial situation and stated long-term goals. What is the most appropriate course of action for the advisor to take? Option A. Advise the client that the requested investment is too risky and refuse to execute the trade without further discussion or exploration of alternatives. Option B. Recommend a diversified portfolio of low-risk investments that the advisor deems suitable, regardless of the client's expressed interest in the speculative stock. Option C. Conduct a comprehensive suitability assessment, including a detailed review of the client's financial situation, investment objectives, and risk tolerance, to determine if any investment, including the one requested, is appropriate, and then discuss the findings and suitable alternatives with the client. Option D. Proceed with the investment as requested by the client, assuming the client understands the risks involved and has the ultimate authority to make their own investment decisions. The correct answer is C. Conduct a comprehensive suitability assessment, including a detailed review of the client's financial situation, investment objectives, and risk tolerance, to determine if any investment, including the one requested, is appropriate, and then discuss the findings and suitable alternatives with the client. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated preference and the advisor's fiduciary duty to act in the client's best interest, particularly within the regulatory landscape of Ontario, Canada. The advisor must navigate the potential for misinterpretation of client instructions, the obligation to provide suitable advice, and the need to maintain client trust while adhering to provincial securities regulations. Careful judgment is required to ensure compliance and ethical conduct. Correct approach analysis. The best professional practice involves a thorough assessment of the client's financial situation, investment objectives, and risk tolerance before recommending any investment. This approach aligns with the fiduciary duty mandated by Ontario securities law, which requires advisors to act honestly, in good faith, and with a view to the best interests of the client. Specifically, Ontario Regulation 1015/09, General, under the Securities Act, Ontario, emphasizes the need for suitability assessments. By engaging in a detailed discovery process, the advisor ensures that any recommendation, even if it initially seems to align with a client's stated preference, is genuinely appropriate and in the client's long-term financial well-being. This proactive due diligence prevents potential harm to the client and upholds the advisor's professional integrity. Incorrect approaches analysis. Recommending the investment solely based on the client's expressed desire without a comprehensive suitability assessment constitutes a significant regulatory and ethical failure. This approach disregards the advisor's fiduciary obligation to ensure that investments are appropriate for the client's specific circumstances, potentially exposing the client to undue risk or unsuitable products. It violates the principles of investor protection embedded in Ontario securities legislation. Another incorrect approach would be to dismiss the client's preference outright without understanding the underlying reasons or exploring alternatives. This can damage the client relationship and may overlook valid, albeit perhaps miscommunicated, client needs. Finally, proceeding with the investment after a cursory check that doesn't delve into the client's full financial picture, even if the client insists, still falls short of the required standard of care and could be seen as a failure to adequately discharge the advisor's responsibilities under Ontario's regulatory framework. Professional reasoning. Professionals should adopt a client-centric decision-making process that prioritizes understanding the client's holistic financial situation and objectives. This involves active listening, probing questions, and a commitment to educating the client about the implications of their choices. when a client's stated preference appears to conflict with their best interests. The professional's role is to bridge that gap through informed discussion and by presenting suitable alternatives, always grounded in regulatory requirements and ethical principles. The ultimate goal is to facilitate informed decision-making that benefits the client. Question 17. Compliance review shows that a financial advisor in Ontario is working with a client who has expressed a strong desire to invest a significant portion of their portfolio in a single, high-growth technology sector. Despite the advisor's assessment indicating this strategy carries substantial concentration risk and is not fully aligned with the client's long-term financial objectives and moderate risk tolerance, what is the most appropriate course of action for the advisor to take? Option A. Recommend the client's preferred strategy while subtly downplaying the risks of sector concentration and emphasizing the potential for rapid gains. Option B. Advise the client that their preferred strategy is too risky and refuse to implement it, regardless of the client's insistence. Option C. Clearly explain to the client the potential risks and downsides of concentrating their investments in a single sector, detailing how it deviates from a diversified portfolio aligned with their stated financial goals and risk tolerance, and then proceed based on the client's informed decision. Option D. Proceed with the client's preferred investment strategy as requested, as the client is ultimately responsible for their investment decisions. The correct answer is C. Clearly explain to the client the potential risks and downsides of concentrating their investments in a single sector, detailing how it deviates from a diversified portfolio aligned with their stated financial goals and risk tolerance, and then proceed based on the client's informed decision. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent conflict between a client's stated preference and the advisor's fiduciary duty to act in the client's best interest, particularly when that preference may lead to suboptimal outcomes or increased risk. The advisor must navigate this delicate balance while adhering strictly to the regulatory framework governing financial advice in Ontario. The challenge lies in providing advice that is both compliant and genuinely beneficial to the client, avoiding undue influence or misrepresentation. Correct approach analysis. The best professional practice involves clearly explaining to the client the potential risks and downsides associated with their preferred investment strategy, specifically highlighting how it deviates from a diversified portfolio aligned with their stated financial goals and risk tolerance. This approach prioritizes transparency and client education. By detailing the specific implications of concentrating their investments in a single sector, the advisor fulfills their obligation under Ontario's Securities Act and the Investment Industry Regulatory Organization of Canada, IIROC, rules to ensure clients understand the products and strategies recommended. This empowers the client to make an informed decision, even if it differs from the advisor's initial recommendation, while still upholding the advisor's duty of care and best interest. Incorrect approach is analysis. Recommending the client's preferred strategy without a thorough discussion of the risks and alternatives fails to meet the advisor's duty of care and best interest obligations. This approach prioritizes client satisfaction over prudent advice, potentially exposing the client to undue concentration risk and violating principles of responsible investing. Proceeding with the client's request solely based on their insistence, without adequately documenting the risks discussed and the client's understanding, also creates a significant compliance gap. It suggests a failure to adequately assess suitability and could be construed as a breach of regulatory requirements to act in the client's best interest. Finally, attempting to subtly steer the client towards the preferred strategy by downplaying the risks of diversification or overemphasizing the potential of the single sector would be a misrepresentation and a violation of ethical conduct and regulatory expectations for honest and fair dealing. Professional reasoning. Professionals should adopt a framework that begins with understanding the client's stated goals and risk tolerance. This is followed by an objective assessment of suitable investment strategies, considering regulatory requirements for suitability and best interest. Any divergence between the client's preference and the objectively suitable strategy must be addressed through clear, comprehensive, and documented communication. The professional must explain the rationale behind their recommendations, highlight the risks and benefits of all viable options, and ensure the client fully comprehends the implications of their final decision. This process safeguards both the client and the professional from regulatory breaches and ethical lapses. Question 18. Investigation of a long-term client's unusual trading patterns in their Ontario-based investment account raises concerns about potential insider trading. The client, a senior executive at a publicly traded company, has recently made several large, illiquid trades shortly before significant company announcements. What is the most appropriate course of action for the financial advisor? Option A. Discreetly gather further information to corroborate the suspicion and consult with the firm's compliance department and legal counsel before taking any further action. Option B. Ignore the trading patterns due to the client's established history and perceived trustworthiness to avoid jeopardizing the client relationship. Option C. Advise the client to move their assets to a different jurisdiction or financial institution to avoid regulatory scrutiny. Option D. Immediately report the suspected insider trading to the Ontario Securities Commission, OSC, based on the initial observations. The correct answer is A. Discreetly gather further information to corroborate the suspicion and consult with the firm's compliance department and legal counsel before taking any further action. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a financial advisor to balance client confidentiality with the obligation to report potential financial misconduct. The advisor must navigate the delicate line between protecting a client's privacy and fulfilling their duty to uphold regulatory standards and prevent harm to the financial system or other investors. Failure to act appropriately could lead to significant legal and ethical repercussions. Correct approach analysis. The best professional practice involves discreetly gathering more information to confirm the suspected misconduct without directly confronting the client in a way that could be perceived as accusatory or breach confidentiality prematurely. This approach prioritizes a thorough, evidence-based assessment before taking any definitive action. The advisor should then consult with their firm's compliance department and potentially legal counsel to determine the appropriate reporting procedures under Ontario securities regulations. This aligns with the principles of due diligence and responsible conduct expected of registered individuals, ensuring that any reporting is done in accordance with legal requirements and internal policies, thereby protecting both the client and the advisor. Incorrect approach is analysis. Directly reporting the suspicion to the Ontario Securities Commission OSC without further investigation or consultation with the firm's compliance department is premature. This could violate client confidentiality unnecessarily if the suspicion is unfounded and could lead to an unwarranted investigation, damaging the client's reputation and the advisor's relationship. Another incorrect approach is to ignore the suspicion due to the client's long-standing relationship and perceived trustworthiness. This would be a direct violation of regulatory obligations to report suspicious activities and could expose the advisor and their firm to severe penalties if the misconduct is later discovered. Finally, advising the client to move their assets to avoid scrutiny is unethical and potentially illegal, as it facilitates the concealment of potential misconduct and constitutes aiding and abetting. This action directly contravenes the advisor's duty to act in the best interests of the market and uphold regulatory integrity. Professional reasoning. Professionals facing such situations should employ a structured decision-making process. First, recognize the potential red flags and the ethical and regulatory implications. Second, prioritize information gathering and verification, adhering to internal policies and client confidentiality protocols. Third, consult with internal compliance and legal experts to understand specific reporting obligations and best practices within the relevant jurisdiction, Ontario. Fourth, act decisively and ethically based on confirmed facts and expert advice, ensuring all actions are documented. Question 19. Comparative studies suggest that client preferences can sometimes diverge from investment suitability. In Ontario, Canada, if a client of a registered investment advisor insists on purchasing a specific mutual fund that, based on the advisor's initial assessment, appears to be a high-risk option not aligned with the client's stated moderate risk tolerance and long-term retirement savings goals, what is the most appropriate course of action for the advisor to take? Option A. Proceed with the purchase of the mutual fund, but only after obtaining a signed waiver from the client acknowledging the risks, without conducting a full suitability assessment. Option B. Inform the client that the fund is unsuitable and refuse to process the transaction without further discussion or exploration of alternatives. Option C. Immediately execute the purchase of the mutual fund as requested by the client to honor their explicit instruction. Option D. Conduct a thorough suitability assessment, including a detailed discussion with the client about their financial situation, investment objectives, risk tolerance, and knowledge of investments, to determine if the requested fund is indeed suitable or if alternatives should be explored. The correct answer is D. Conduct a thorough suitability assessment, including a detailed discussion with the client about their financial situation, investment objectives, risk tolerance, and knowledge of investments, to determine if the requested fund is indeed suitable or if alternatives should be explored. Explanation. This scenario is professionally challenging because it requires navigating a conflict between a client's stated preference and the advisor's professional obligation to ensure suitability and compliance with regulatory standards. The advisor must balance client autonomy with their fiduciary duty and adherence to the Ontario Securities Commission (OSC) regulations. The correct approach involves a thorough investigation into the client's financial situation, investment objectives, risk tolerance, and knowledge of investments, even if the client expresses a strong preference for a specific product. This aligns with OSC Rule 31-505 Conditions of Registration, which mandates that registrants must deal fairly, honestly, and in good faith with clients. Specifically, the advisor must conduct a comprehensive suitability assessment before recommending any investment, regardless of client insistence. This ensures that the recommendation is appropriate for the client's circumstances and that the client understands the associated risks and benefits. The advisor's duty is to act in the client's best interest, which includes providing objective advice and not simply executing a client's potentially unsuitable instruction without due diligence. An incorrect approach would be to immediately proceed with the client's request without further inquiry. This fails to meet the deal fairly, honestly, and in good faith standard, and bypasses the crucial suitability assessment required by OSC regulations. It prioritizes client instruction over regulatory obligation and the client's actual best interest, potentially exposing the client to undue risk and the advisor to regulatory sanctions. Another incorrect approach would be to dismiss the client's request outright without attempting to understand the client's rationale or educate them on the suitability concerns. While the advisor has a duty to ensure suitability, a complete dismissal without dialogue can damage the client relationship and may not address the underlying reasons for the client's preference. A professional advisor should aim to educate and guide the client towards suitable options. Finally, an incorrect approach would be to recommend a product that is clearly unsuitable, even if the client insists, without documenting the client's insistence and the advisor's concerns. While the intent might be to satisfy the client, proceeding with a known unsuitable recommendation without robust documentation and a clear explanation of risks to the client is a failure of professional duty and regulatory compliance. The professional reasoning process should involve 1. Acknowledging the client's request. 2. Initiating a comprehensive suitability assessment to understand the client's financial profile and objectives. 3. If the requested product appears unsuitable, engaging in a detailed discussion with the client to explain the concerns, the rationale behind the suitability assessment, and to explore alternative suitable options. 4. Documenting all discussions, assessments, and decisions thoroughly. 5. If after thorough discussion and education, the client still insists on an unsuitable product, the advisor must consider their obligations under OSC regulations and potentially refuse to execute the transaction if it would violate those obligations or put the client at significant, unmitigated risk. Question 20. The investigation demonstrates that a client in Ontario, Canada, is considering selling a portion of their investment portfolio. The client purchased 100 shares of XYZ Corp for $20 per share on January 15, 2020, and incurred a commission of $50. On July 10, 2021, the client reinvested a $100 dividend, which increased their ACB. On March 5, 2023, the client sold all 100 shares for $45 per share, incurring a commission of $75. Assuming the capital gains inclusion rate is 50%, what is the client's estimated capital gains tax liability in Ontario, Canada for this transaction, using a hypothetical Ontario provincial tax rate of 10% on taxable capital gains? Option A, $150. Option B, $1,000. Option C, $1,200. Option D, $1,080. The correct answer is D, $1,080. Explanation. The investigation demonstrates a scenario where a financial advisor in Ontario, Canada, must accurately calculate the potential capital gains tax liability for a client's investment portfolio to ensure compliance with Canadian tax law and provide sound financial advice. This is professionally challenging because miscalculations can lead to significant financial penalties for the client, damage the advisor's reputation, and violate regulatory obligations under the Ontario Securities Commission (OSC) and the Investment Industry Regulatory Organization of Canada (IIROC) rules regarding client care and accurate advice. The best professional approach involves meticulously calculating the adjusted cost base act for each security, determining the proceeds of disposition, and then calculating the capital gain or loss for each asset. This is correct because it directly adheres to the principles of the Income Tax Act, Canada, and IIROC client-specific advice requirements. Specifically, the ACB is the total cost of acquiring an investment, including commissions and fees, and is used to determine the taxable gain or loss when an asset is sold. The proceeds of disposition are the amount received from selling the asset. The capital gain is calculated as proceeds of disposition ACB. Only 50% of a capital gain is taxable in Canada. This precise calculation ensures that the client is aware of their exact tax obligation, allowing for informed decision-making and proper tax reporting. An incorrect approach would be to estimate the capital gains tax based on a general tax rate without considering the specific ACB and proceeds of disposition for each individual security. This is ethically and regulatorily flawed because it fails to provide accurate, client-specific advice as mandated by IIROC client care rules. It also risks underestimating or overestimating the tax liability, potentially leading to tax evasion or overpayment of taxes, both of which are serious breaches of trust and regulatory compliance. Another incorrect approach would be to only consider the initial purchase price as the cost base, ignoring any subsequent capital contributions or reinvested dividends that might have increased the ACB. This is a failure to adhere to the Income Tax Act's definition of ACB, which can significantly distort the capital gain calculation and lead to an inaccurate tax assessment. A further incorrect approach would be to assume a flat 50% inclusion rate for all gains without verifying if the gains are indeed eligible for the capital gains inclusion rule, or if there are any specific exemptions or deductions that might apply. While the 50% inclusion rate is standard, a professional advisor must ensure all relevant tax provisions are considered. The professional reasoning framework for such situations involves a systematic data-driven approach. First, gather all relevant transaction data for the client's portfolio. Second, apply the relevant tax legislation, in this case, the Income Tax Act of Canada, to calculate the ACB and proceeds of disposition for each asset. Third, calculate the capital gain or loss and the taxable portion thereof. Fourth, communicate these findings clearly and transparently to the client, explaining the assumptions made and the basis for the calculations. Finally, document all calculations and advice provided for compliance and audit purposes.